Andrew writes, my organization recently terminated an employee and made a severance offer. However, the terminated employee had objections to the non-disparagement language in our standard severance agreement, claiming that it was too broad. Is non-disparagement language permitted in a severance agreement, and is this something we should insist on? We are hesitant to pay severance if the employee can trash the organization's reputation after taking the money. Okay, this comes up quite a bit and fairly often for me in my practice, Mike. Mike, are you familiar with non-disparagement? Have you seen that kind of language? I'll
I
explain what it
am
means for
very
everybody. But
familiar with it, but I am not like a lot of people. I think I probably have things that I think about that might not reside exactly in the law with the case, and would like to see where I'm really looking forward to this question when I saw you send it over, where you think
yeah,
there's some tripping and falling hazards here.
yeah, and it's basically language that says the parties agree not to make derogatory, defamatory, or other statements that will tarnish the other party's reputation, and that's made a part of the agreement. That each party agrees they're not gonna, as the Andrew put it, not gonna trash the other party after they've decided to enter into this, basically a settlement. A severance agreement is a kind of settlement. The tricky part comes when you're dealing with an employee. First of all, there are some tripping points. You can't, for example, have a provision that keeps somebody from exercising their rights to engage in concerted activity under National Labor Relations Act, Section 7. That applies even if an organization is not unionized. And past employees talking to current employees, that can be a part of concerted activity. And there could be statements that are deemed derogatory as part of that process. So I usually have that as a carve out if an organization really wants to have this language. Another tripping point, state law has been developing a lot in recent years where they're more and more prohibiting this kind of thing to the extent that it would stop an employee from getting facts out to the public about harassment they've experienced, discrimination, other violations of the law. So more and more, you're needing to look through, understand what state law could apply, and have carve-outs for that as well, just so you're totally clear that you're not violating an employee's right. Because if you cross one of those statutes, you're putting the settlement agreement at risk, the severance agreement. And just kind of on the softer side of things, I work exclusively with nonprofit organizations, and I'm more and more talking to them and trying to move them away from very broad approaches and very hardline approaches to this kind of language for a few reasons. Number one, it is practically speaking hard to enforce because, okay, you get a severance agreement, then you hear how it works usually in the real world. You hear that an employee is saying some things or posting something. Do you as an organization then want to be in the position of suing that person or sending a legal letter saying you cannot be saying these things anymore? That tends to not make the organization look very good, tends to make the organization look like they've got something to hide, even though the sentiment is totally reasonable. But when you've got a nonprofit, as Mike, you and I talk about all the time, really your reputation and the trust of the organization is the main thing you have that's going to give you the ability to pursue your mission off into the future. And it just doesn't look great when these things inevitably surface, especially in the news or people who are not attorneys. They love to pick out this kind of language and say, oh my God, look at what this organization was requiring. They were basically shutting down all differing opinions about the organization. They've got strict, broad, non-disparagement language. So it's something you want to really think about. It usually doesn't work out as well in practice as you would think from just the basic concept, which on its face is not unreasonable. What do you think about that?
Yeah, I have a pretty obvious question I want to ask you. With all that said, and where there's always caveats in these in a typical severance agreement, I'm assuming there's some general language on disparagement, and versus not having the language, right? Knowing that it's
Yeah.
there sometimes in name only.
And what I've done sometimes is have a version of this, good faith efforts to refrain from statements that would unnecessarily damage the other party's reputation, just kind of soften the standard.
But to be clear,
Maybe
you're
stressing,
recommending language to be in there versus not having any disparagement type of
well,
reference.
some form of it is helpful
Yes,
because at least it will make a person think twice
exactly.
before just going off and risking their severance payment to just leave a really nasty post somewhere online or something like that. So some version of this is helpful. Clearly, you can prohibit defamatory statements, things that are false, but where it gets really broad is language that just would try to restrict somebody from disclosing true facts
Overly.
and try to restrict somebody from just expressing an opinion. That's where it gets more tricky and it might make the organization look bad. So you might experiment with softer versions of this.